Ladies and gentlemen, hit subscribe to this channel, especially if you're new to this channel. Hit subscribe right now. This will be the definitive live stream on why there will almost certainly be a 9-0 Supreme Court victory for Trump, a unanimous Supreme Court victory for Donald Trump. Thank God. That'll be in about a week. I use the word soon within the title. And let's get started. You will hear from all the justices, and you will hear from Trump in South Carolina later in this live stream. To read my writing in The Hill, The Huffington Post, Salon, The Jerusalem Post, The Federalist, other publications, go to hagoodman.com. I'm starting off with the Daily Beast. Federal Bureau of Investigation has found no evidence Trump or allies organized a rebellion. End of story. The Federal Bureau of Investigation found no evidence. There was zero evidence of any effort to overthrow the government or engage in a rebellion. Hit subscribe. You will hear right now from Justice Alito getting a little bit upset at the Colorado lawyers, and you'll hear from liberal justices as well, who I believe will also side with the majority in this case. Absolutely historic. We are all witnessing history. To my super chat, if you want to go ahead and if you want to, ladies and gentlemen, give a super chat during the live stream while you're hearing the justices. Your support is greatly appreciated. Thanks, everybody. Let's start.
Justice Alito.
Suppose there's a country that proclaims again and again and again that the United States is its biggest enemy, and suppose that the President of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country. Could a state determine that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This court has never interpreted the aid and comfort language, which also is present in the treason clause. But commentators have suggested it's been rarely applied because treason prosecutions are so rare. But commentators have suggested that, first of all, that aid and comfort really only applies in the context of a declared war, or at least an adversarial relationship where there is, in fact, a war between two countries.
So, Justice Alito, really quickly, to give you some context, is asking the Colorado lawyer, hey, if Trump hasn't been convicted, can other states decide on whether or not a president has been disloyal simply because of a different foreign policy than the prevailing paradigm of foreign policy? So when Trump became president, they said, oh, why is he altering President Obama's foreign policy towards the Kremlin? Well, President Obama came in with a Russian reset, and he altered Bush's foreign policy. That's why you vote for a president, because you want a different foreign policy and economic policy, which is why Trump will be victorious in November. We had record low poverty with Trump, record highs in household median income. Interest rates weren't through the roof. We can go on forever. But Colorado did not wait for Trump to be convicted of any crime. They simply said, we think, it's the opinion of experts, the logical fallacy of appeal to authority. Well, we think that he engaged in a rebellion, so therefore, and so Alito is asking, Justice Alito is asking, does that also apply to a different foreign policy? Does that also apply to other topics? Where does it stop? And that's why a lot of the liberal justices are asking the same types of things. They're saying, hey, this is a state-level decision that's affecting a federal election. Furthermore, he hasn't been convicted. And also, Section 3 of the 14th Amendment does not give the states, any state, a right to influence 49 other states. Hit subscribe right now if you're new to the channel.
Countries. And second, the intent standard would do a lot of work there, because under Section 3, Whatever the underlying conduct is, engaging in insurrection or aid and comfort has to be done with the intent to further the unlawful purpose of the insurrection or to aid the enemies in their pursuit of war against the United States.
Now, let me come back to the question of what we would do if different states had adjudicated the question of whether former President Trump is an insurrectionist using a different record, different rulings on the admissibility of evidence, perhaps different standards of proof, then what would we do?
Ultimately, this court would, first of all, if there were deficiencies in the record, the court could either refuse to hear the case or it could decide on the basis of deficiencies of the record.
Well, would we have to decide what is the appropriate rule of evidence that should be applied in this case? Would we have to decide what is the appropriate standard of proof? Would we give any deference to these findings by state court judges, some of whom may be elected? Would we have to have our own trial?
No, Your Honor. This court takes the evidentiary record as it's given, and here we have an evidentiary record that all the parties agree is sufficient for a decision in this case. And then, as I discussed earlier, there's a possibility of a Bose Corp independent review of the facts. But ultimately, what we have here is an insurrection that was incited in plain sight.
Yeah, you're really not answering my question. It's not helpful if you don't do that. Suppose we have two different records.
Is an insurrection that was incited in plain sight.
Yeah, you're really not answering my question. It's not helpful if you don't do that. Answering my question. It's not helpful if you don't do that. Suppose we have two different records, two different bodies of evidence, two different rulings on questions of admissibility, two different standards of proof, two different sets of fact findings by two different judges, or maybe multiple judges in multiple states. Then what do we do?
Well, first, this court would set the legal standard, and then it would decide which view of the record was correct. I think under that, if this court had two cases,
which view of what record?
So if 50 states have 50 different viewpoints, that's okay under Section 3 of the 14th Amendment? Is that how it works? Justice Alito is asking the Colorado lawyer to explain how their decision that Trump engaged in a rebellion is different from their decision. The Colorado Supreme Court could say that Trump's foreign policy was treasonous. They could say that they could say President Obama's foreign policy was harming the United States and he was giving comfort to enemies. And so therefore, I mean, you look at a deal with one country in one region of the world that President Obama and Biden and Democrats wanted to further, and they've been testing missiles long after they signed a deal, okay, with nuclear capacity. So is that good for the country? Did they betray the country with that foreign policy? Where do you stop? If the Colorado Supreme Court can say that Trump committed a rebellion without him being convicted, what else can they say based on the sensibilities of wonderful, morally superior, highly educated liberal Democrats who are experts in this historical era? You can find conservative experts, Victor Davis Hanson being one, a whole bunch of historians who will say that what Colorado did was unconstitutional and absurd. But what happens is it's a public relations nightmare. Then you get hit pieces, then you get media going after you. But if you support the prevailing mentality, experts say, well, then you're lauded and you're championed. And then that's why when you watch MSNBC or ABC News or CNN, or you read the Washington Post, these historians, these law scholars are saying that Trump, the walls are closing in. They're not saying that a 9-0 Supreme Court will do what Sean Kemp did in the 90s to the Golden State Warriors. You can type in Sean Kemp. And the dunk was one of the greatest slam dunks in history. That's what Trump will be doing very soon, next week. Or the Supreme Court will be doing that. Hit subscribe if you're new to this channel.
If this court had two cases before it, and both of the records were sufficient insofar as both sides had the opportunity to present their case and the essential facts in the record that everyone agreed was sufficient for decision, then this court would have to look at the evidence presented and decide which holding was correct, and then decide that issue for the country. And certainly here, when there is a complete record, lower courts then will be applying that decision, and I think it's unlikely that any court would say, we're going to reach a different decision than the U.S. Supreme Court did, particularly if the court relies on the facts, the indisputable facts of what President Trump said on video and in his Twitter feed, which is really the essence of our case here.
The essence of their case is what Trump said on video, a deceptively edited video that removes context, where he uses the word peaceful and patriotic and support and respect law enforcement. Where on Twitter he then says keep calm and leave the area and all of that. That's the essence. You've criminalized Trump's personality. He didn't act the way you would have liked, so therefore he's a criminal? Is that how it works? He engaged in a rebellion because people committed crimes just in terms of chronology after his speech, therefore it's his fault and he engaged in a rebellion? Because if you want to look at a Democrat making a specific, very harmful, possibly illegal statement towards specific justices, which led to one justice almost losing his life, and thank God it didn't happen, but because of the rhetoric of Democrats, let's go here. We can go right here. We can go right here. Top Democrat right here. I wonder what the Colorado Supreme Court would think of this top Democrat in the Senate. I wonder what the Colorado Supreme Court would think of this.
Rights. I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions.
So, a top Democrat can say you will pay the price? Is that how it works? Is that how it works? A top Democrat can say, you will pay the price, and specifically mention the name of two Supreme Court justices, directing his rhetoric towards two individuals on the Supreme Court, and that's not a rebellion? And that's not fomenting chaos and mayhem and illegal activity? Because one of these justices almost had his life taken from him because of such rhetoric. Are they going to impeach or remove Schumer from office? If he runs for president, is he barred and banned by the Colorado Supreme Court? Oh, no, of course not. That's for Trump. We had specific statements. You won't know what hit you? Really? Oh, okay, you'll pay the price? Really? Trump never said that. Trump never said anything close to that. And again, a deranged person almost, well, tried to end the life of one Supreme Court justice. And so is Schumer responsible directly for that? And then is he banned from Colorado under Section 3 of the 14th Amendment from regarding running for office? So it's only Trump's words we're looking at, not the Democrats. And this is just one of many things stated by Democrats that are far infinitely worse than Trump. Just like when Charlemagne the God was talking to Joe Biden, and Biden says, "You ain't who you are if you don't vote for me." Trump never said anything like that. And immediately the Washington Post, "Oh, that's not that big of a deal. Trump is worse. Trump is worse." Trump is not worse. Democrats get away with far worse. Trump never had a laptop with bribery schemes. Anyway, let's continue.
You had an expert, let's just take that example, had an expert testify about the meaning of what President Trump said. But do you think it's possible that a different state court would apply Daubert differently and say that this person should not be allowed to express an expert opinion on that question? You think that's beyond the realm of imagination?
Not at all, Your Honor. 2 points on that. Number one, President Trump didn't appeal the admission of that evidence in this case. But number two, the second point is that Professor Sini he didn't opine on the meaning of President Trump's words. He opined on the effect that those words had on violent extremists. And the essence of his testimony was built.
So was there an effect? Was there an effect that Schumer's words had on a person that almost ended the life of a Supreme Court justice that Trump nominated, Kavanaugh? Schumer was very direct and frighteningly clear in his sentiment. Did that affect anyone? So we're to believe only that Trump's words lead directly to chaos and mayhem, but not Schumer's.
Built around videotaped statements of President Trump himself encouraging, inciting, and praising political violence.
I'm not.
He absolutely did not praise political violence. He absolutely did not do that, ever. So that's not accurate.
Taking a position one way or the other about whether the expert's testimony should have been admitted or anything like that, or the meaning of President Trump's words. I'm just trying to get you to grapple with what some people have seen as the consequences of the argument that you're advancing, which is that there will be conflicts in decisions among the states, that different states will disqualify different candidates, but I'm not getting a whole lot of help from you about how this would not be an unmanageable situation.
If this court writes an opinion affirming on the basis of the indisputable facts of what President Trump said.
They're not indisputable facts. They're in dispute. Nobody believes, most people don't believe that Trump engaged in a rebellion. So most people do not believe that. Nor was he convicted of that. So, I mean, that's a huge issue here. That is a huge issue. You have a situation, ladies and gentlemen, where we already have Federal Bureau of Investigation found no evidence Trump or allies organized rebellion. By the way, Nicholas, thank you. to my super chat. Thank you, Nicholas. Thank you so very, very much. Greatly, greatly appreciated, Nicholas. Thank you. There will be a 9-0 decision, ladies and gentlemen. And it's going to be one of the most amazing moments in U.S. history. And you saw, I mean, that was... we can even look at, let's look at one of the liberal justices. So this is Justice Jackson.
So when I asked you earlier about the uniformity concern and the troubling potential disuniformity of having different states enforce Section 3 with respect to presidential elections, you seem to point to history in a certain way. You said, I think, that the framers actually envisioned states enforcing Section 3, at least in some circumstances where there were insurgents and Confederates. And I guess in my view of the history, I'm wondering really whether presidential elections were such a circumstance, that the framers actually envisioned states enforcing Section 3 with respect to presidential elections as opposed to senatorial elections, representatives, the sort of more local concerns. So can you speak to the argument that really Section 3 was about preventing the South from rising again in the context of these sort of local elections as opposed to focusing on the presidency?
Well, 2 points on that, Justice Jackson. First is that, as I discussed earlier, there isn't the same history of states regulating ballot access at this time. So ballot access rules to restrict presidential candidates would.
But he's not answering the question. The question was, you'd have 50 different states if this ruling went through, and this is Biden's nominee. She's 100% right. She's asking, you're going to have, she's telling him you're going to have 50 different state Supreme Courts, possibly with 50 different viewpoints on a variety of topics. So how does this unify the country?
Wouldn't have existed. They wouldn't have been raised one way or another.
Right, but I'm not making a distinction between ballot access and anything else.
Understood, but the more broad point I want to make is that what is very clear from the history is that the framers were concerned about charismatic rebels who might rise through the ranks up to and including the presidency of the United States.
But then why didn't they put the word president in the very enumerated list in Section 3? The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred, and president is not there. And so I guess that just makes me worry that maybe they weren't focusing on the president. And, for example, the fact that electors of vice president and president are there suggests that really what they thought was, if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
This came up in the debates in Congress over Section 3, where Rhetoric Johnson said, why haven't you included president and vice president in the language? And Senator Morrill responds, we have. Look at the language, any office under the United States.
Yes, but doesn't that at least suggest ambiguity? And this sort of ties into Justice Kavanaugh's point. In other words, we had a person right there at the time saying what I'm saying. The language here doesn't seem to include president. Why is that? And so if there's an ambiguity, why would we construe it to, as Justice Kavanaugh pointed out, against democracy?
Well, Rhetoric Johnson.
So this is a brilliant takedown from Biden's nominee, Justice Jackson. Okay? You already have the conservatives, 6 of them. I think that just from this exchange, Justice Jackson will vote alongside the 6. And then you have Justices Kagan and Justice Sotomayor, who also completely steamrolled the Colorado lawyers in the same manner. You have the liberal justices. This is huge, ladies and gentlemen. I find it fascinating. If you're new to the channel, hit subscribe. This is going to be a 9-0 unanimous decision protecting democracy, protecting the republic, protecting the Constitution in a manner that the Colorado Supreme Court and those trying to disenfranchise 70 to 80 million Americans who want Trump in a manner that offers a historic biblical rebuke of such nonsense. You cannot prevent a presidential candidate from seeking office because liberal sensibilities tell you and liberal historians tell you that he basically committed a rebellion, even though the Federal Bureau of Investigation found no evidence. Again, no evidence that Trump or allies organized anything. Well, let's continue.
Johnson came back and agreed with that reading. Any office is clear. The Constitution says about 20 times.
No, I'm not going to that. So let me just say, so your point is that that there's no ambiguity. With having a list and not having president in it, with having a history that suggests that they were really focused on local concerns in the South, with this conversation where the legislators actually discussed what looked like an ambiguity. You're saying there is no ambiguity in Section 3?
Let me take the point specifically about electors and senators, if I might, because I think that's important. Presidential electors were not covered because they don't hold an office. They vote. And this.
No, I'm talking about the barred office part of this.
Exactly. So the barred office is, if you want to include everybody, first you have to specify presidential electors because they're not offices, so they wouldn't fall under any office.
The problem is that Justice Jackson is asking, why doesn't it specifically say presidential candidate or a president of the United States is barred? Or a person seeking the presidency is barred. It doesn't say that. And within the text, most would assume that it's everybody but the president, not including the president. And so Justice Jackson asked, well, why doesn't it state that the president or the presidency, or that an officer is the president also, can be the president also? It doesn't state that. That's one of the key arguments, in addition to the fact that Trump didn't commit a rebellion, in addition to the main issue that a state cannot ruin the whole entire federal election for everybody. That's not what James Madison wanted, or it's not what the framers of the Constitution wanted. They wanted the system to work, not completely shut down when MSNBC 200 years later convinced one state Supreme Court that Trump committed a rebellion, and even the Federal Bureau of Investigation couldn't find evidence. And furthermore, he used the word peaceful, and furthermore, people were let into the building by law enforcement. I mean, how do you come to a conclusion that Trump committed a rebellion? How on earth can you? Are people completely ignorant of history? Is this what the French Revolution was about? People just let into buildings by law enforcement? No.
Second of all, senators and representatives don't hold office either. The Constitution tells us that under the incompatibility clause and refers to them as holding seats not offices. And so you want to make sure that there's no doubt that senators and representatives are covered. Given that the Constitution suggests otherwise, you have to include them. The Constitution says the presidency holds an office, as do members of this court. And so other high offices, the president, vice president, members of this court.
All right, let me ask you, I appreciate that argument. If we think that the states can't enforce this provision for whatever reason in this context, in the presidential context, what happens next in this case? I mean, is it done?
If this court concludes that Colorado did not have the authority to exclude President Trump from the presidential ballot on procedural grounds, I think this case would be done, but I think it could come back with a vengeance, because ultimately members of Congress may have to make the determination after a presidential election if President Trump wins.
That ain't going to happen. Number one. Number two, Luke St. Martin. I'll take things Robert's going to foul. Luke St. Martin, thank you. Chad Davis. Chad. We love you, Chad. And Oklahoma. I love Oklahoma. I love you, Chad. Thank you. We love you, Chad. Thank you so much. Luke St. Martin, thank you. That's great. That is fantastic. Luke St. Martin, thank you. To my super chat, thank you so much. Greatly, greatly appreciated. So, as you can see, ladies and gentlemen, this is actually Biden's nominee. And Justices Kagan and Justice Sotomayor were the same. There's only 3 liberals on the Supreme Court, and then Roberts, like Luke St. Martin was referring to. Chad and Luke, thank you. This is huge, ladies and gentlemen, absolutely huge. We are heading towards a 9, even if it's 5-4, which it won't be. Because it's not, you don't even have to be a constitutional scholar. You don't have to be a constitutional scholar to understand that this is not going to be close. This is going to be an absolute rebuke of watching too much MSNBC and CNN and reading too much of the Washington Post or New York Times. Okay? People don't say these are far left publications or cable stations, but they are. They really are. They don't represent what the mainstream of the country feels, which is why Trump is up over Biden. So Justice Jackson has showed the world, along with the exchange from, here you can see Justice Kagan as well, here. Here, this is Justice Kagan.
Put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, you know, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on.
So you heard from Justice Jackson. That was Justice Kagan. Okay. So that was Justice Kagan. And I mean, that should tell you right there, you have two of the three you just heard. Two of the three Supreme Court justices you just heard right now. Two of the three liberal Supreme Court justices. And Justice Sotomayor asks brilliant questions of the Colorado lawyers also. They just can't answer. They can't answer. Nicholas, by the way, thank you again. Thank you again, Nicholas. Thank you. So, you have Colorado, the lawyers saying, well, you know, we're not doing anything that's going to affect the federal contest. We're asking you. And it's like, yeah, you're asking the Supreme Court because you just had a detrimental effect on the entire electoral process by bringing this nonsense to the Supreme Court to begin with. The man obviously didn't commit a rebellion. He hasn't been. The Federal Bureau of Investigation has no evidence that he organized anything. This is pure fantasy. And again, liberal sensibilities become reality when the mainstream media says the same thing over and over again. It becomes a reality. So much so that you suddenly have the Supreme Court involved, which is complete and utter nonsense. Complete and utter nonsense. The Supreme Court should never have been involved. Okay, but let's listen to Amy Coney Barrett. She's awesome. And I mean, we're heading towards a 9-0 unanimous decision, ladies and gentlemen. Do you know what that alone will boost Trump, because I don't think that they realized what a 9-0 decision would do. I just don't think they realized that. I don't think that they realized they wanted to just throw a Hail Mary pass like Roger Staubach. Okay? They wanted to throw a Hail Mary pass, and they just, you know what? And if it was a 6-3, they could say, "Oh, the Supreme Court is compromised by Trump and the right." But if it's 9-0, baby, which I believe is going to be 9-0, and this whole lead up to the week, we'll do a whole lot of these segments, live streams. I think that's going to be pretty amazing. It's going to be an absolutely historic rebuke. Refutation. It is going to be a true, and Mitchell, the lawyer for Trump, was brilliant, absolutely brilliant. And no offense, you could tell the Colorado lawyers were just trying to kind of not really answer the questions because they couldn't. They have a very tough case. They're trying to accuse Trump of something he didn't do by repeating a fantasy. Oh, well, because he engaged in this rebellion, and this rebellion and this rebellion. It's like, well, he didn't. He didn't, number one. And number two, you have to convict the person first of a rebellion before you simply say, we think he did. You can't say we think that he did. You can't say we think that Trump committed a crime, so therefore he's not eligible to be president. That makes no sense at all. Let's continue. Actually, you know what? Let's listen to Trump in South Carolina. So this is we've heard a lot of the Supreme Court. We'll continue to hear, but South Carolina's coming up. Huge victory there. He'll defeat Haley by like 30 points, and you'll get a 9-0 Supreme Court ruling, and he'll regain the Oval Office in November. What more could you want for this year? I do think, heaven forbid, there will be a stock market crash. I don't wish that. I don't want that, but I think there will be because of Biden's policies and the Democratic Party's policies. But let's continue. This is Trump in South Carolina.
Well, I want to thank everybody. I think I'll just do it this way. The hell with that. I want to thank everybody. This is incredible. We took what was known as a big arena. It's not too big because we'll have to do another one. We'll come back soon. We'll get everybody in. But in the meantime, I hear you have screens. Do they have screens? Yes? They have big screens where you can watch. I wish you could come in. I just want to thank this state has been so incredible. Your governor, your lieutenant governor, Russell, thank you very much, have been so incredible. It's been so incredible. So we have a country that's failing. We have a country that we feel very badly about. 4 years ago, we were a great nation. Today, we're a nation that's being laughed at, and we're not going to stand for it. We're going to win in November. We're going to turn our country around. It's going to be greater than ever before. The spirit that I've seen, so we did great in 2016. We won. We did much better out here, but I'm coming back, and we're going to make one where everybody can get in. We'll get the biggest arena or the biggest piece of land, or we'll take over an airport or something, but we'll get everybody here. And we're going to get them all in, or we're going to get them on, and we're going to give the best speech you've ever heard. I want to I just have to thank you. Your governor's been a friend of mine for a long time. I don't want to say it too loud, but the fact is, it was more important to get Henry McMaster to be governor than it was to have her at the United Nations. I have to be honest. And he did a much better job. So, again, thank you. I'm going to speak. You're going to listen. And I'm going to come back, and we're going to get everybody into that arena. Maybe we'll have to build a new arena because this was supposed to be the biggest one. Or we'll just simply have it outdoors. Thank you all very much. We love you. Go and vote. So you have early voting on Monday, so get in there and early vote. We love you. Thank you all. Thank you, everybody. Thank you.
Doesn't he sound more energetic? Isn't there more electricity, more passion, more energy, more enthusiasm when he speaks as opposed to our current president, mashed potato brains? You look at Trump, the man has more energy than most people, like a lot of people 20 years, 30 years younger than than him. So, bottom line, ladies and gentlemen, is that it's going to be a 9-0. It's almost certainly going to be 9-0. And the reason it's going to be unanimous is the following. You're going to have a very difficult time convincing. See, if this is a piece of legislation, for example, where like a law or a recent law within the last 100 years, okay, labor law or some kind of law pertaining to healthcare, whatever, you could then interpret, you're asking Supreme Court justices to interpret laws to see if they're constitutional or unconstitutional. When you start asking them about American history, Little Dove, hello. When you start asking them about American history, and you start giving history lessons, you ain't going to win. All nine of these people, Cabley, exactly. All nine of these people on the Supreme Court are historians. They're not just legal scholars or they're historians also. It's like their passion in life. Every single Supreme Court justice is a much more knowledgeable and educated historian and possesses more wisdom than a constitutional scholar or a lawyer that just happens to be a liberal Democrat or a traditional Republican, whatever. If you see things through the lenses of political party and you're trying to convince the Supreme Court that in the 1860s and the 1870s, what they really meant was to stop Trump, you ain't going to win. That's a losing proposition. You ain't going to win if that's the case. So, I will be back tomorrow, 3 p.m. Eastern, everybody. 3 p.m. Eastern. Okay? And we will have an amazing live. We'll do 2 live streams a day forever, at least 2 live streams. I'm also going to be building the Stock Market Crash channel and the Bitcoin Crash channel. So, but you're going to be able to see, Trump's speeches. You're going to be able to see Supreme Court arguments. You're going to be able to see a lot of, I've revamped the live streams to make them more educational, entertaining, informative, and fun. So, hit subscribe if you're new. To my super chat, Chad and Luke and everyone here, thank you so much. Nicholas, thank you so much for gifting all of those memberships. I cannot thank you enough. And I appreciate your support, everybody. Thanks, everybody. God bless. Dave, thank you. I'll see you tomorrow, everyone. Thank you so very, very much. Hit subscribe.